While some individual-level data for judicial elections is available, its availability is limited, especially in comparison to this type of data for congressional and presidential elections. This is especially prevalent when seeing the lack of data on voter participation in judicial elections. While the educational background and the political knowledge of the voting population have been found to be important factors in terms of who turns out to vote, especially in elections that are not highly publicized, overall, very little analysis on who participates in those elections has been conducted. However, it has also been suggested by the limited data that has been conducted that the partisanship and ideology of the candidates and electorate does not play a particularly important role in determining who wins these elections. However, other examples of individual-level data have been conducted for judicial elections, including why candidates run in these elections. Most of the time, their reasons for running may include them being encouraged to do so by their friends and colleagues, or by attorneys' dissatisfaction with their current law firm. One of the most interesting findings based on the data that does exist is the performance of female judicial candidates. While women are underrepresented in most levels of government, the judicial branch is an exception to this rule. Research has found that female candidates for judicial office tend to outperform their male counterparts. While voters generally see men as better at cracking down on crime, they also value judges who are, quote, empathetic, compassionate, and trustworthy, a quality they believe women encompass more than men. Additionally, with the public generally having a different perception of judges compared to other elected officials, including legislators, this further helps women secure fair representation in the judicial branch in several states. However, opposition to judicial elections remains strong, including from Lambda Legal, an LGBTQ+ rights legal advocacy group. They oppose judicial elections on the grounds that, according to the organization, judges are not politicians and they should not factor public opinion into their decisions, as public opinion may be against basic human and civil rights, and, as they state, quote, if judges can't safeguard the rights of vulnerable minorities without fear of retaliation, that dynamic renders our constitutional right to due process extremely vulnerable. They also quote retired U.S. Supreme Court Justice Sandra Day O'Connor, who has stated, when you enter one of these courtrooms, the last thing you want to worry about is whether the judge is more accountable to a campaign contributor or an ideological group than to the law. In addition, the organization mentions how the Supreme Court's decision in Citizens United v. FEC opened the floodgates to outside spending, which can also be attributed to the rise in outside spending in judicial elections as well as other elections. Citizens United was a Supreme Court decision in which the court ruled that placing limits on how much entities such as corporations and labor unions could spend on elections was unconstitutional, as these limitations constitute a prior restraint on speech. Fortunately, Lambda Legal mentions positive developments towards judicial election reform in the Supreme Court case of Williams-Yulee v. the Florida Bar, in which the court ruled that states could ban judicial candidates from asking for donations, owing to the fact that they create the appearance of corruption, a sentiment that is, once again, reflected in the court of public opinion. The case, Lambda Legal argues, paves the way towards securing further reasonable restrictions on judicial campaign conduct in the states that elect judges. As Chief Justice John Roberts wrote in the majority opinion for the Williams-Yulee ruling, the question the court had to consider was whether or not free speech was limited in the cases of soliciting donations that appear to create a conflict of interest. Quote, we hold that it does. Judges are not politicians, even when they come to the bench by way of the ballot, and the state's decision to elect its judiciary does not compel it to treat judicial candidates like campaigners for public office. A state may assure its people that judges will apply the law without fear or favor, and without having personally asked anyone for money. We affirm the judgment of the Florida Supreme Court. Indeed, academics have found a correlation between judicial elections and mass incarceration. A 2019 study conducted by UCLA professor Christian Dipel and Columbia University professor Michael Poyker, researching the impacts on state judicial elections since 1980, found that states had, quote, a statistically significant relationship between judicial elections and longer sentences. These states are North Carolina, Pennsylvania, and Washington State. In North Carolina particularly, defendants get more than 5 months on average added to their sentence when a judge is facing re-election, possibly in part for them to appeal to an electorate that prefers judges who are more, quote, tough on crime. In addition, in the state of Georgia, the study finds, judges are likely to sentence blacks to up to 2.5 additional months in an election year, while blacks receive an average of an additional 6 months in Alabama. This correlates somewhat to an earlier study conducted 2 years prior by Wellesley College professor Kyung Park. Quote, Park found that the incarceration rates in Kansas rise by 2.2 to 2.6 percentage points in an election year, but only for black defendants. That translates to a 10% increase in the likelihood of incarceration for black defendants in election years. In their study, Professors Dipel and Poykarth point to Virginia as the only state where they concluded that judges are more likely to hand out more lenient sentences towards the end of their terms, due to Virginia judges being appointed by the governor and confirmed by the legislature rather than elected by the voters. They use this piece of evidence to argue that having appointed judges leads to the lowering of the incarceration rate. In addition, in states that do elect judges, but where the judicial elections are generally much less competitive than in other states, they did not find a correlation between tougher sentences and judicial elections. Building on Lambda Legal's argument that judicial elections force judges to pay attention to the will of the people, even if it means countering basic human rights, in the wake of the U.S. Supreme Court's 2015 ruling in Obergefell v. Hodges, which ruled that same-sex marriage is a constitutional right in all 50 states, Senator Ted Cruz was vehemently against the court's decision and argued that it was a sign that an appointed judiciary was out of touch with the American people and that they needed to face election. The senator argues that the court's decision, quote, undermines not just the definition of marriage, but the very foundation of our representative form of government, and is, quote, the latest in a long line of judicial assaults on our Constitution and the common sense values that have made America great. In arguing his belief that Supreme Court judges must face the voters, he writes, judicial retention elections have worked in states across America. They will work for America. In order to provide the people themselves with a constitutional remedy to the problem of judicial activism and the means for throwing off judicial tyrants, I am proposing an amendment to the United States Constitution that would subject the judges of the U.S. Supreme Court to periodic judicial retention elections. Every justice, beginning with the second national election after his or her appointment, will answer to the American people in the states in a retention election every 8 years. Those justices deemed unfit for retention by both a majority of the American people and as a whole, and by a majority of the electorates in at least half of the 50 states, will be removed from office and disqualified from future service on the court. Although Cruz, as a conservative, states that it is not an easy position to take, he believes it to be necessary due to his belief that, quote, the court's hubris and thirst for power have reached unprecedented levels, end quote. Further evidence on the relationship between judicial elections and sentencing can be found in the April 2008 edition of the American Journal of Political Science in the form of a study called State Public Opinion, the Death Penalty, and the Practice of Electing Judges. The study finds that, due in large part to public opinion in support of capital punishment, elected judges are more likely to hand down death sentences. As the Equal Justice Initiative, an anti-death penalty legal advocacy group, explains, controlling for factors including quality of representation and complexity of the case on appeal, the study found that, in states that elect judges, higher levels of public support for capital punishment are associated with significantly lower probabilities of voting to reverse death sentences. Indeed, Lambda Legal cites an additional study conducted by the American Constitutional Society suggesting that politics play a part in appeals, which found that elected judges are more than twice less likely to reverse death sentences than appointed ones. This is a central piece of evidence as they argue their opinion that judicial elections are wrong. The notion that voters in many states prefer tough-on-crime judges is evidenced by the fact that, during the 2014 election cycle, more than 4 out of every 5 attack ads for judicial elections focused on candidates hammering their opponents for being soft on crime, in some cases going as far to imply that these judges give lenient sentences to convicted murderers and sexual assaulters, sentences that they say do not match the severity of the crimes committed. Additionally, many candidates may be attacked from the other side for representing criminal defendants. An example of this occurred in 2012, when the Michigan Republican Party released an attack ad against University of Michigan Law School professor Bridget McCormick, then a candidate for state Supreme Court, for having, quote, volunteered to represent terrorists at Guantanamo Bay and fighting to protect sexual predators. Similarly, ads touting a candidate as being tough on crime are also relatively common in judicial elections. A state in which this is prominent is Alabama, where 3 Supreme Court candidates, Claude Nielsen, Kenneth Ingram, and Sue Bell Cobb, ran ads touting their support for the death penalty and being very liberal with their upholding of capital punishment sentences from juries. In particular, Ingram's campaign ran an ad during his 1996 campaign, highlighting the daughter of a mother who was murdered by somebody who he sentenced to death. The daughter thanked Ingram for sentencing the murderer to death in the ad. 10 years later, as Cobb ran for Chief Justice of the state Supreme Court, she touted the fact that she had sentenced more defendants to death than any other candidates for office that cycle. A similar dynamic played out in Tennessee in 2014, as 3 state Supreme Court justices, Justices Clark, Wade, and Lee, were all facing retention elections and were being targeted by conservatives for being, quote, liberal on crime. In response, they highlighted the fact that they upheld the death sentences of nearly 9 out of 10 defendants who received the death penalty, and they all survived their elections. These examples provide opponents of judicial elections evidence that these types of elections are detrimental to the concept of judicial independence, as they take public positions on the campaign trail that they are held to once they are elected to serve on the bench.